Good afternoon, everybody. I have 12 o'clock exactly, which means we're going to dive into today's topic. Our topic today is ethics and ethical considerations in New Jersey workers' compensation cases. And before you turn that channel, this actually is an important topic. I know ethics sometimes doesn't feel like the most exciting topic. We have some updates to the presentation, and I'm going to bring in some case law, some of it pretty recent, to talk about how this actually plays out in our workers' compensation cases and how important ethical considerations are in defending employers and insurers. And we're going to look at this from two perspectives. We're going to look at it from the perspective of the petitioner's counsel and the ethical obligations that they have that are specific to them. And then we're going to talk about it from the perspective of defense counsel as well. As always, this presentation is not legal advice. It is offered as an educational presentation only. The material is all based on Chapter 18 of my book, which we write every year for LexisNexis. And just a few weeks ago, our 2025 edition just came out. And so this presentation has been updated to match the latest edition of the handbook that I write on New Jersey workers' compensation law. So we're going to talk a little bit about where ethical rules come from, and then we're going to look at the considerations for each side, for the petitioner side and defense side. And I'm going to talk a little bit practically about how this plays out in the way we defend cases and the way we hold the other side to account. Because remember, when we talk about ethics rules, we're really talking about what are the boundaries, what are the rules that we're going to make sure that petitioner's counsel is holding to when they are representing their client. So let's begin with just a quick description of where these rules come from. Some of them come from the rules of professional conduct, which have been adopted into the New Jersey rules of court. Now, interestingly, in the 70s, there was a legal unification project which really came up with model rules of professional conduct, which nearly every jurisdiction has adapted or adopted. Now, I also teach this presentation for the New York workers' compensation practice here at LOIS. And what's fun about this is all the same rules have the exact same numbers, and most jurisdictions will have the same numbers. So even if you're paying attention to this and you have cases in other jurisdictions, almost every jurisdiction has the same numbering scheme for the same rules of professional conduct because they've all adopted the model rules. New Jersey's workers' compensation rules, which are placed inside the administrative code, have some other specific rules that apply to workers' compensation attorneys. And then interpreting all those rules are ethics opinions, which come from advisory committees on ethics, and then, of course, case law surrounding ethics decisions. So that's where we come up with the corpus of rules that we're going to discuss today. Now, let's turn quickly to the rules that apply primarily to petitioner's counsel and the ones that are specific to them. So let's talk about first the rules about how they become the representative of the petitioner. Section 64 of the New Jersey workers' compensation law says that a workers' compensation attorney's representation begins or is incepted with the filing of the formal claim petition. And really, that's all they have to do under the law to be the representative of the claimant. However, we think it's best practice, and we included in our handbook, that there should probably be a special letter or description of what the representation is going to entail. So, for example, petitioners' attorneys will often send a letter to their client that says, hey, you signed the claim petition, I'm representing you in this workers' comp case, but please understand this representation is limited to the workers' compensation proceeding, and if there are any appeals that need to be taken, etc., I don't represent you in regards to those. So they like to limit down their representation to just what's happening in the workers' compensation case. How does a petitioner's attorney get out of a workers' compensation case? Well, they can substitute out, meaning another attorney comes in and becomes the successor attorney. That is done by way of a formal process. They file a motion to withdraw as the attorney, and then the court approves it, and now they can be substituted in for a new attorney. How do they get out of the case? Well, they can substitute out and someone else comes in, but that's a formal process, so we'll have notice of that. And sometimes a petitioner's counsel will want to substitute out or withdraw from representation and leave the claimant or the petitioner pro se. Judges do not typically like that. They don't want the petitioner to be unrepresented, and so will oftentimes grant long continuances and adjournments so the petitioner will have time to find new successor counsel. And while it hasn't happened that much in this jurisdiction, it has happened in, for example, our New York jurisdiction, where petitioners' attorneys had problems with referral sources, meaning they were using runners, they were paying claimants to sign up to file cases. And we have seen them withdrawing en masse, withdrawing from hundreds of cases all at the same time due to issues with referral sources, and then leaving the petitioner or the claimant pro se. It's problematic. The courts don't generally like that. The next set of rules that apply to petitioner's counsel also apply to us. And those are the rules surrounding client contact. The court rules say that the petitioner has to be kept, quote, reasonably informed, close quote, about the progress of their case. And they have to be reasonably informed enough to be able to participate in the case and make decisions about what's happening in the case. This is the number one source of complaint about petitioners' attorneys that is brought before grievance boards, is that they've gone dark or silent and they are not communicating anymore with their own client. So that's problematic. The other aspect that this comes into that we see from our defense side is when we're making settlement offers to petitioners' attorneys. The petitioner's attorney has an absolute obligation to bring that settlement offer to their client. They can't reject it out of hand or to say, I'm not even going to bring that to my client. And they've said that to me, right? I've actually made offers to settle cases, and opposing counsel said, Greg, that offer is an insult. It's so low, I'm not even going to bring it to my client. I have to say, well, actually, under the rules of professional conduct, you have a duty to bring it to your client. And the rule also says that, quote, a lawyer shall abide by their client's decision whether or not to settle a matter, which means the ultimate power to decide to settle is up to the claimant, the petitioner, not their attorney, right? So this is important. This rule means that both the petitioner has to be informed about the settlement offers that we're making, and they get the final decision. So when opposing counsel says to me, Greg, that offer's low, I'm not even going to bring it to my client. I say, I'm sorry, you have to bring that to your client. I have to remind you of the rules of court. Now, the way this sometimes will play out in court, in a trial context, is the petitioner will be on the stand and they're ready to testify and go through all of their aches and pains and, tell their story. And one of my first questions when I'm cross-examining them is, are you aware that we made settlement offers to resolve this case? Are you aware that we offered you? And then I'll go through literally the offers that we've made to try to avoid the trial. And I do this on purpose because the petitioner will sometimes say, well, I didn't even know there was an offer to settle. I was unaware of that. It is not a breach of attorney-client privilege for me to ask that question. I'm simply trying to figure out, hey, were you aware that we actually made legitimate offers to settle your case as your case was progressing, or was that kept from you? And I want to bring that out on the record because maybe it's going to be the fundus or the background for me to bring a grievance against the attorney. But oftentimes, this is when you settle cases, when the claimant's on the stand and they take a break and they go and they talk to their attorney. It's like, I'll take that money. I don't want to go forward with this trial. So that's an important thing for us to follow up on as defense counsel. Now, the next thing I'll talk about is pre-litigation contact. So in workers' compensation court in New Jersey, our powers as your respondent's attorney begin with the filing of a formal claim petition. But that's not often where the case begins. I have clients that contact me in a pre-litigation state and they say, Greg, we have this problem, we have this issue. Sure, we're going to talk about it. I'll give you some pre-litigation advice. We have a wonderful intake department that helps with that and make sure that you have the decisions that when you're making those decisions, you have the benefit of counsel. And that's, again, before the case is filed. But I also have clients who will say, hey, Greg, we know that this accident occurred. We want to look into this person's background. We want you to go get all their prior medicals. And I'll say, listen, that's a great idea, but we cannot do that until a formal claim petition is filed. In other words, there is no such thing as formal pre-litigation discovery. For example, I don't have subpoena power until a formal claim petition is filed, right? So we'll counsel clients through that. But remember, petitioner's counsel is doing a lot of pre-litigation investigation. And this is the thing for us to be cautious about. They are allowed to contact, for example, the employer before the formal claim petition is filed and ask questions or say, I need this person's payroll or wage records, or I need a copy of the accident report. And oftentimes employers will actually comply with that. Of course, this is kind of a minefield for the petitioner's attorney because during that pre-litigation contact, they have to be very clear and say, I represent this claimant. We haven't brought a formal claim yet, but we're anticipating it. And here's what I'm going to be doing. Now, the second place that this comes into play is in admissions made by the employer, which then become imputed to the carrier later. So I'll give you an example of this. The employer who immediately says, oh, there was an accident at work, we're going to accept it as compensable, and they start treating it as a compensable accident, even if it is not. There is case law in this jurisdiction, and there is statutory reference or statutory support for the idea that when the employer says, I'm accepting this case, it's compensable, and then the carrier later comes in and says, no, it's not, that the court can look at that and say, well, actually, they admitted it. They treated it as an admitted case. This is why we always say, hey, if the case is questionable and you want to treat it as compensable, that's fine. But at least in your answering statement, say under investigation in regards to compensability. So you leave that opportunity open to challenge whether or not this is truly a compensable case or not. All right. So just be mindful that in this jurisdiction, admissions made by the employer, even pre-litigation, can be used against the carrier and used to strip them of their defenses in later defending that case. So that's an important moment for us to think about. Contact with the treating physician, contact with the expert physicians. In this jurisdiction, New Jersey, it's fairly common for petitioner's attorney to have direct contact with the treating physician. They will call them up and say, hey, can I have a copy of the medicals? Can I have a copy? When is the next scheduled appointment? And generally speaking, that stuff is accepted and acceptable and doesn't violate any rules. The best practice in this jurisdiction, of course, because we control and direct care in this jurisdiction, is as medical treatment is developing, as the claims professional or adjuster is receiving copies of those narratives, those medical records, forward them to defense counsel, and then rely on us to send them to opposing counsel. That makes sure that they're kept in the loop and that they do not have to communicate directly with the treating physician. But again, that's not a per se violation. It is a per se violation for them to attempt to communicate with our independent medical expert. And we deploy independent medical experts in this jurisdiction very frequently as to the need for further treatment, whether or not the petitioner has reached maximum medical improvement, to defend motions for med in temp, and of course, to assess permanent residual disability. It is per se inappropriate for petitioner's counsel to communicate with our IME physicians at all. That's considered attorney-client privilege. And so that's very important for us to defend. There are some conflicts of interest that can emerge that are unique to this jurisdiction. And the most common one is where the petitioner's attorney is also representing an applicant who is seeking a medical provider claim payment. In those situations, they're really actually adverse almost to their own client because they're saying, hey, my client's treating physician didn't get paid enough, and you need to issue an additional payment consistent with New Jersey's usual and customary scheme. That sets up a conflict for petitioner's counsel and is per se inappropriate. Other rules that apply to the petitioner's counsel are their duty to be truthful to the judge and truthful to the other parties. You know, the attorney rules of professional conduct state that we cannot, for example, conceal facts. We cannot hide truth. We cannot present testimony that we know is going to be fraudulent. And when we know that there is legal authority that stands to the contrary of the argument that we're making in court, we have to turn over that contrary authority, that legal authority, to the judge. Well, those same rules apply to petitioner's counsel as well. They cannot present a witness, for example, that they know is going to testify falsely. It creates a conflict for the attorney. So those are the general rules that apply to petitioner's counsel and that we help the court to make sure that they comply with. Let's turn to ethical issues for Respondents Counsel. And here's where it gets interesting, I think. Um, the first thing is that defense counsel in most, or I should say about 50% or more of workers' compensation cases, we're representing two parties at once. We're representing the actual insured or the employer, and we're representing an insurance carrier as well, who has a contract to indemnify and provide a defense to that policyholder, right? So we have two clients at once, and this is often called the triadic or tripartite relationship. And this is one of the only areas in law at all where this is ever allowed, where one attorney can represent two parties in the same litigation. However, it's very clear that the insured or the policyholder is the true master or the one that we owe the highest duty of allegiance to. And the insurance carrier is owed that second level of or reduced level of fealty, right? So that is the special relationship here. And it seems counterintuitive, right? So we here at Lois, about half of our practice is defending insurance carriers and their insureds. And about half our practice is defending self-insureds. And we define, by the way, self-insureds here as high deductible insured. So if you have a self-retention of $1 million or a deductible of $1.5 million, I consider you a self-insured. It's essentially all your money in 99.99% of your cases, right? We don't have this issue with self-insureds. In other words, it's clear who we represent. It's the self-insured. It's all their money all the way down. They're making the financial decisions, and we owe that duty of defense to them. And it's really clear we have this one sole client. A little more complicated when we're defending an insured, because we're also defending the insurance carrier, and we have that tripartite relationship. Now, the ethics opinions and the duties that we owe are very clear. The ethics opinion that I go back to came from 1954. It's Goebel's aircraft specialties case, and the court said, quote, when counsel, although paid by the casualty company, meaning insurance company, undertakes to represent the policyholder and files his notice of appearance, he owes to his client, the assured, meaning the insured, an undeviating and single allegiance. His fealty embraces the requirement to produce in court all witnesses, facts, and experts who are available and necessary for the proper protection of the rights of his client. The canons of professional ethics make it pellucid that there are not two standards, one applying to counsel privately retained by a client and the other to counsel paid for by an insurance carrier, close quote. Now, when you really think about the history of the law and the law of ethics and the rules of ethics, I should say, this really came to the fore in the 40s and 50s, and that's why this case is so old. It's almost 75 years old at this point, because we're starting to see large-scale industrial concerns, and we're seeing a lot of insured. So they had to address this issue. And again, it's one of these things that I like to stress, particularly with new attorneys, which is, hey, your first and highest duty is to the employer. Your second duty is to the carrier. You can never confuse those two. And they'll say to me, but Greg, insurance carrier X spends $500,000 here at Lois and sends us 80 cases a year. And I said, that's great. But remember, our first duty is to actually all of those insureds or those policyholders for whom they refer these cases to us to give them a credible defense, right? So you have to keep that in mind. And again, this is an interesting little wrinkle or interesting area of law because it allows for this. Now, there's a lot of cases that I could show you or talk about that explores all the issues that surround this, right? When you're defending both the insurer and the policyholder at the same time. Because what happens, for example, when the policyholder is doing something shady? Well, the case in 94 that I'm going to talk about first is Montanez. Montanez is driving his vehicle. His wife is a passenger in the vehicle. They get in a car accident. And the car accident, who's the issues in the case were like who caused the car accident, how injured was his wife, who else was responsible. So all the issues that you can imagine. The case goes to trial with Montanez, the driver of the vehicle, telling his insurance company, I wasn't at fault. I wasn't negligent. I was doing everything right. Okay, this wasn't my fault. Even though my own wife, who is a passenger, is suing me and saying I was negligent, I wasn't. Okay. The insurance carrier meets with their own insured many times, including the claims representative audio taping him while he says, yeah, I was just driving along. I heard a pop. I think it was a blowout. My car got out of control. That's when we had the car accident. I wasn't being negligent. I wasn't speeding. I wasn't drunk. All of those things. So they record him saying this. Now they go to trial. And now he gets on the stand, and during the trial, he starts lying. He starts saying, well, actually, I didn't hear this pop. I didn't know what was going on. He starts saying, yeah, maybe I was responsible. And then literally says, I'm testifying this way because I want my wife to get the biggest possible recovery, right? So in other words, he's now saying he is negligent and is at fault in this accident because he's realizing, well, this is going to give my wife the best potential avenue of recovery against my insurance carrier. So the defense counsel is sitting there who put him on the stand for the purpose of him showing that he wasn't negligent. Now he's on the stand, says the opposite, says I was very negligent. He said, I have a real problem here. And he says, Your Honor, I want to approach this witness as hostile. I want to treat them as an adverse witness. The judge allows him to do that. And then he confronts the witness by saying, hey, didn't we record you giving a statement? And in that statement, didn't you say you weren't at fault? And didn't you say that you did not cause the accident? Didn't you say? And he says, yes, yes, yes. I don't remember saying any of that. So the defense counsel ends up becoming attacking or impugning the credibility of his own insured. This case goes all the way up to New Jersey's appellate division, which says, wait a second, even though it looks like your insured's behavior was fraudulent, or at best he's colluding with his wife to create a fake case so that she could win this giant award, you're not allowed to do that. You're not allowed to attack the credibility of your own insured, because now you have stepped into the shoes as only serving the interests of the carrier, and you're throwing your own insured under the bus. And the court actually instructs that when this happens, when you believe that your own insured, again, the policyholder, is doing something fraudulent, you have to choose defense counsel. You can defend one or the other. You can defend that policyholder, or you can defend the carrier, but you cannot defend them both at the same time because their interests are no longer aligned. Okay, so that case, and that's an extreme case, right? Because he's clearly up there lying on purpose and colluding with the plaintiff in the case. So even in that extreme example, our duty as the defense counsel is still to say, well, we're just going to stop the trial right here. I need to confer with my client, and then we need to bring in extra counsel, a second set of attorneys to represent the insurance carrier, because what we're developing here on the record means I cannot represent them both at the same time. This also comes up in the workers' compensation context, and particularly in the context where the policyholder, the insured, is also the owner of the company, right? And those should be, by the way, your red flag cases where you should be saying, wait a second, when it's the owner of the company who's bringing a workers' compensation case against themselves and maybe are the only witness as to what they're up to, those are really problematic cases and fraught with a potential for conflict. In the case that I'm going to talk about that was just decided a few years ago in 2022, Alum is the petitioner in the case. And the case was brought against a company called Ameribuilt, which was insured by Travelers Insurance. He's the 50% owner of Ameribuilt Inc., a corporation. He claims he got injured in a work-related motor vehicle accident. Well, Ameribuilt says, yeah, we do have coverage. Travelers is the policy issuer. Travelers assigns defense counsel who's going to defend both Ameribuilt and Travelers, both at the same time. As they investigate this case, they say, wait a second, you said you were driving from one work site to another work site, but your car accident actually took place way out of the way. And so they said, you know what, this is an exception to the workers' compensation rule of portal-to-portal coverage because you deviated from your normal route. And because you deviated, it's not covered by workers' compensation. So they raise a defense that, hey, did not arise out of and in the course of employment. Ultimately, Alum says, you know what, fine, I'll settle with my own insurance carrier. Let's do a Section 20. It's undisclosed how big the Section 20, but let's say it's $10,000. They go before the law judge because remember, in New Jersey, a workers' compensation judge has to approve every Section 20 lump sum dismissal settlement. And the judge says, I'm sorry, I can't approve this Section 20 because you, defense counsel, have a conflict. The petitioner owns the company, Ameribuilt, and you're taking a position adverse to him. If the petitioner is stating that he was in the course of employment, then you cannot essentially raise the defense that he wasn't, and if you do, you're creating a conflict. So this is interesting, right? Because now you have your own employee who is the 50% owner of this corporation who gets in this injury, you have a strong defense that it did not arise out of in the course of employment. You can prove that because you can say, here's the accident location. Here's the two places he said he was going. He was nowhere near those two places. This could not have arisen out of the course of employment. He agrees, right? The policy will say, yeah, I can't probably prove this. Let's do a Section 20 lump sum dismissal, right? Which is a payment without admitting liability, essentially. And the judge comes in and says, no, defense counsel, you have a conflict because on the one hand, you're saying he's your client and you're defending him. On the other hand, you're saying, but he's a liar and he's not entitled to what he's entitled to. Well, this went up to the appellate division, who came forward and said, essentially, well, yes, they can represent both the company, Ameribuilt, and the carrier, because it's a corporation and he's just one of the corporate shareholders. He's not the sole owner, and so therefore there is no conflict there. So it's interesting. And again, it just demonstrates that these conflict issues for defense counsel do emerge. They're pretty frequent, and you can find a lot of reported case law on it. The thing we need to keep in mind is that even though the insurance company is oftentimes paying me for my time and expense and my hours, my client is really their insured, and that's the client that I owe the highest duty to. The case law is pretty clear in our jurisdiction. It says that we have to communicate, we have to make sure that we treat everybody fairly. But if there ever is an issue between the carrier and the employer, the employer's concerns come first. Another issue, or something that we like to note about most New Jersey workers' compensation policies, is the carrier does not need the permission of the employer to settle a case. So we do not have to get their consent to a settlement if we think that's in the best financial interest of both the insured and the carrier as well. And then there is case law in New Jersey that says, the carrier does not have to disregard its own interest, but again, it must put the interest of the insured first. Now, the other area that this comes into in terms of conflicts is with litigation management guidelines or legal billing guidelines that attempt to control or limit how zealous defense counsel can be in defense of insureds. And so this is something that, litigation guidelines, they're relatively uniform now throughout most of the industry. Almost every one of the clients that we serve has pretty similar litigation guidelines. Probably the biggest area I see now where they're all starting to do their own thing is with the use of AI. Some of our clients in their litigation management guidelines are like, you can use it. Some say you can't. Some say you can use it, but it's all your problem if it goes south. Generally, arbitrary impositions of limitations on what the defense can do for the insured will be found to create a conflict for defense counsel. And the other issue where I see potential for conflict, or really just challenging the boundaries of ethics, is representations that exceed the workers' compensation contract or the policy. So I'll give an example of this. You remember that about half of our business here at LOIS comes from insurance carriers that write a workers' compensation policy to cover the insured. Well, those policies do not cover things like, for example, doing general releases or doing things like resignations from the employment. And there's two reasons for that. First, it's just not in the standard workers' compensation contract that everybody sort of adopts and used, right? And also, it exceeds what the workers' compensation law allows in this jurisdiction. There is no provision in the workers' compensation law that says releases or resignations can be covered by workers' compensation law. And in fact, the opposite. They say, if you're pressuring your own employees to resign, that could be a violation of your duties under the workers' compensation law as an employer. So it's just simply not covered. But it's one of those areas where we're constantly being asked questions like, hey, we want to separate this employee, we want to terminate them. Do we have grounds to do it? And so we have to give advice, or we are asked to give advice that would exceed the boundaries of the workers' compensation contract. Now, we don't have the same problem for self-insureds because obviously there is no workers' compensation contract that would govern the relationship between the carrier and the employer. And so when the employer comes to me and says, Craig, we want to do a resignation, we want to do a general release, or any other thing, hey, we're going to terminate them. Do you think we've papered this file up? I say, do you have a good, valid business reason to terminate them? Okay, go ahead. there's no problem there because that relationship and my retention is not governed by a contract or policy. Okay, just to sum this up a little bit, um, we have the same duty of candor towards the tribunal that petitioners' attorneys do. And that means that we have to tell the truth to the judge. We can't present testimony that we know is going to be false, and we can't conceal things, right? We can't conceal things as well. And that extends to sworn pleadings. There's a lot of pleadings that we are going to file and serve in this jurisdiction. This is a motion-heavy jurisdiction in which we need to file a certification in support of every motion. Those are all sworn pleadings, and I remind my attorneys, hey, you're swearing to these things as an officer of the court, so be very thoughtful, have to be absolutely, completely truthful in all of those pleadings. And there are significant penalties if we are found to not be truthful. The judge in this jurisdiction has really wide-ranging power that has never been limited really by case law to apportion fees, which means the judge at the end of a workers' compensation case could technically say, okay, respondent, your pleadings were misleading the court. I'm going to apportion all fees against the respondent. That's something that the judge can do. We also have a duty to be in contact with and communicate with and cooperate with our adversaries. That means that we're not here to delay things, engage in frivolous litigation, or ask for unnecessary continuances or adjournments. In fact, our policy at LOIS is to never ask for a continuance or adjournment and to try to push cases forward. Unfortunately, this jurisdiction allows or grants adjournments for almost any reason, including no reason at all. And that's why the administration of justice is so slow in this jurisdiction. The judges definitely will allow the petitioner unlimited, essentially, adjournments, even for basic things that they should have already gotten done, basic discovery. They will enlarge time for almost anything to be as liberal towards the petitioner as they possibly can be. However, our policy is always to try to push litigation forward. And in fact, what we do when we think the other side is not being cooperative or is not bringing their case forward in a timely manner with a normal pace, we file a motion to dismiss for lack of prosecution. And we'll do that even when the petitioner adjourns the case for no reason. We'll say, Judge, can you please mark this not moved so that we can move forward and move to dismiss for lack of prosecution. All right, so that is a little bit of a review of ethics in this jurisdiction. I'm going to stop sharing my screen now, and I'm going to move over and see if there's any questions. Feel free to unmute yourself if you want to verbally ask me a question, or I'll look and see if there's any questions typed up for me to review. I love questions, by the way. It makes this way more fun for me. So let me scroll down. It looks like this thing is showing us some questions from the last time we were here. I'll check into the chat. Do we have any questions here? Anybody? Please, it makes this totally more fun for me. I know ethics is one of those things where maybe as a risk professional, we don't always think about, or maybe you never had a case where counsel had to withdraw due to a conflict. But this is absolutely something that we should be thoughtful about, and certainly holding the other side to account, right? Making sure that they're not getting away with skirting any of the rules of ethics. All right, I'm scrolling through here. I'm checking the chats. I don't see any. So with that, I guess I'll let everybody get back to doing whatever they're doing today. I hope you're enjoying your week and everything's well for you. I'll see you next month. Next month, our presentation is going to be our annual review of the top 10 most important decisions that came out in New Jersey workers' compensation law. So tune in for that. I can't wait to see you all next month. Have a great rest of your week.